table. Appeal in the matter of All Money Matters Ltd and Azhar.
Yes, Mr. Thrower.
Because this is our appeal from an appeal
Yes.
level below. There are skeleton arguments, not just from the past, but I think two from myself and two from my friends.
Yes, well, I can tell you that we've read the skeletons for this appeal and,
Yes.
of course, the circuit judge's judgment. We've also read the skeleton in front of the Deputy District Judge and the contract and the Deputy District Judge's judgment and the transcript of the hearing in front of it.
There's also the leave to appeal by Lady Justice Andrews.
Yes, we've read that too.
Yes, and I would obviously endorse that at the start of this appeal. What I intend to do is just go briefly to three areas to expand or clarify on the skeleton arguments. I hope I won't take too much time with it, but I think it's important because the issues that have been raised in the respondent's notice are actually really wide and of considerable implication. For example, this is a contractual issue, and the authority he relies on indicates there's actually never been a case in which estoppel by convention has been applied to a contractual fact situation. What they said in that case was they didn't see any reason today why it shouldn't, but they did indicate they weren't actually deciding that matter. It is a very rare beast, estoppel by convention, and not very easy to get to terms with as to exactly what constitutes estoppel by convention as opposed to the other forms of equitable estoppel. But I think perhaps on that, I'm going to expand a little bit on the supplemental skeleton I put in. The rest I think is fairly straightforward, but it's just with reference to some of the documents to emphasise why we say what we do.
Yes. But you have to show, do you not, that Judge Lethem was wrong to refuse you permission to argue the point?
Yes. Yes. Could I just start with the claim form just to set it in context?
We're looking at the original or the amended?
It's the amended one on page 204 of the
Yes.
article. So at the outset of the case, the claim alleged that the defendant had accepted an offer in the sum of £1,235,000, and the claimant was entitled to commission. There never had been an acceptance of an offer arranged by the claimant. The claimant must have known that, but he still signed a statement of truth, alleging the truth of the statement that he had arranged a mortgage that she'd accepted. In response to the defence, which simply said, we never did accept a mortgage of this nature or any mortgage arranged by the claimant. There was then an application on at the beginning of the trial to amend very basic amendments to allege 2% of the mortgage offer procured by the claimant, and on around 25th of May, the defendant accepts an alternative mortgage finance in the sum of £1,235,000. So the position on the morning of the trial was that there was an application to amend a very basic form. There's no particulars produced in this claim. And the question arose whether we needed to do anything about answering this basic claim. And the answer was that considering all the parties were in court, all the effort had been made and everybody knew where we were going, perhaps we should get on with it. Now, if I'm wrong about what I agreed to in court at that time, well, that's on me. But I believed in the present day that the idea of adjourning the matter when all the witnesses are there, etc., was quite an onerous thing. And that since everybody understood what the case was about, it should go ahead. And therein lies the problem with the point that we got leave eventually to appeal on, which is the point about there being no confirmation instructions letter.
Yes. You say everybody understood
Yes.
what the point was, but that's really the question, isn't it?
Yes. And in fact, there is abundant evidence that this matter was at the forefront of the proceedings, so much so that in the transcript of the hearing, most of the first minutes of the case were taken with sorting out the bundles, to the extent I think there was a short adjournment while parties went out and produced something that was acceptable. And I should say right now that there are still pages of that bundle that are illegible.
Yes.
And this is the documentation produced by the claimant, documents they relied on, which are illegible. They've been asked, we've never had legible copies. We say that's an example of how cavalier their approach to the whole business has been, that we still can't read some of the terms of the contract. It's possible to make some out. It's possible to get, I think, the gist of some of it. In fact, I hate to say this, but this case has been a little bit cursed by the fact that later on, the bundle for the whole proceedings were mislaid and had to be reconstituted. And then the transcribers said they couldn't transcribe the judgment of Judge Lethem. So my friend Mr. Stevens and myself got working on it, and we managed to decipher it, even though the transcribers say they couldn't.
Right.
But there are problems that we've had in this case. But this is a problem solely of the making of the claimants, and they've been asked, and they've never produced anything that's legible. This is what they had. Goes to trial. We come in with a bundle agreed, and I think it's 12 lines of the transcript later, where the judge asked, where is the confirmation of instructions letter? Right at the very start. And the answer to that is, in effect, well, there isn't such a thing, but there are other things in the contract that can be read as being instructions from the client. And that was the start of it all. And it came up in the case in cross-examination, in closing speeches, and resulted at the end of the day with a judgment in which the judge said there was no confirmation instructions letter. So that was the position in the first instance. We got leave to appeal on the basis that there was no confirmation instructions letter. And my friend then raised the point on appeal that this was a new point. If that's right, then my submission is absolutely staggering.
If it's right, then what?
Then in my submission, it's absolutely staggering that a point that's actually been taken right at the beginning of the trial has been the subject of a specific judgment can be said to be a new point when you go to appeal. And we say that simply cannot be right. And I think that's the gist of what Lady Justice Andrews, she didn't say it was correct, but she said it's arguable successfully that that is the case. So I just very briefly just refer to those particular elements in the trial that indicate that this matter was fully before the court. I think I'll start with, on page 83 of the bundle, I'm not sure we need to go to it. Mr. Stevens, in his skeleton, actually quotes the clause.
This is the skeleton that was before the district judge.
Yes.
Yes.
Then page 104. We have at line 25, so I've worked out when the judge has finished dealing with the bundles, and we get into the meat of the matter.
Yes.
So Mr. Stevens says that 30, so we will need in due course to look at the wording and the definition. If you look at the word arrangement fee, that's the fee set out at clause 22. The lender, meaning any lender who lending proposal presented, finance offer, and this is really where the focus is, sir. A written offer setting out proposed terms of finance, whether the subject was conditional or unconditional, which reflects the terms set out in the confirmation of instructions. This is the word out letter, but that's what it is. And the judge says, where is the confirmation of instructions you refer? You will find that in several places, sir. You'll find it at page 15 in the middle. Oh, that is after the document. Yes, it is, I'm afraid. Sorry, I will try and choose. This is not, this is the fact finding. Yes, it is. This is the confirmation of instructions as well, sir. Well, that would be unusual. Okay, the fact finding is the document required by the regulator in order to take on a client which sets out the base of it. I mean, just about illegible. Page 51 is completely illegible, but page 19 is illegible. I cannot read any of the answers, but okay, this is a fact find, yes. This is not what would normally be considered to be the confirmation of the instructions. It would be what exactly you want. The fact find is the document that's required in order for someone to be before a party that is regulated, a company that is regulated, to be able to determine the basis upon which the instructions are given. So in other words, what you had, what is it that you are seeking me to do, etc. This is not a confirmation of instructions I would normally understand it to be. All right, not particularly I agree with you, but this is not a regulated mortgage product. This is a commercial mortgage, it's a bespoke product. And what you will find, and I'm going to have to ask you to strain your eyes, sir, I'm afraid, on page 21, which you've already looked at, is the confirmation of the instructions. At the very bottom of the page, there's an asterisk. No, I can't read it. So that was the position right in the very beginning. The judge said, where is the confirmation of instructions? But it's the letter. That's what it says. It must comply with the confirmation of instructions letter. Any offer made, a finance offer, must comply with that. And what in fact happens after that is, as I understood my friend's argument, you can actually read into other documents or other parts of this document, the agreement, what these instructions were. Basically, what the judge came down to on that basis was it was clear what she wanted. She wanted a long-term loan. I can't remember, it was 24 or 30 or 48 months, I think it was. Which is effectively a proper mortgage as opposed to a bridging loan. And that's what she was after from the beginning. But then my friend went further and said, you then see amendments or variations as allowed under the contract to the instructions. Now, you can't vary something that doesn't exist. The confirmation instructions letter clearly didn't exist. You can't actually vary that. But my friend said there were variations. There is no evidence. There's no explicit letter from the client saying, this is what I want. All there is on the fact-finding sheet is an indication she wanted a long-term loan, which we know she didn't get, because he explained to her that with her credit rating, that would be difficult. Now, here comes the problem. and I think I must flag this right at the beginning, before the agreement was entered into, Mr. Smethurst's company, well, Mr. Smethurst is effectively the company, sent her 2 mortgage proposals, which were called offers in principle. And they were for long-term loans at a rate of 7.9%. And they were both dated the 2nd of December, and they were sent off 2016, I presume it was at the time. Remembering that the agreement was signed in March the next year. So she sent 2 proposals for a longer term mortgage at 7.9%. And what Mr. Smethurst says in his evidence, quite clearly in 2 places, is the purpose of these 2 documents was to assist Mrs. Azhar in her negotiations with the co-owners of the property to establish a price and, if possible, to buy them out. She'd inherited one part because she was a widow, or in a divorce proceeding, she'd got half of this property. And the other half was owned by effectively by that stage, by the executors of a deceased. So there was to be a mediation meeting on the 29th of March. And twice in his evidence, Mr. Smethurst says, these 2 mortgage offers, in principle, my friend referred to them as indicative offers in the proceedings. These 2 mortgage offers were sent to her, he says, expressly to assist her with the negotiations on the mortgage. What this case comes down to now, if I've got this right, is that the claimant has to pay 24,000 odd pounds as a fee for an offer obtained by Mr. Smethurst, post-dating the mediation meeting, the day after, which contains indicative terms. It says indicative terms, all sorts of things in it. That particular, in inverted commas, offer is introduced by an email from Mr. Smethurst on that day, in which he says that he's happy the meeting yesterday went okay. That was the meeting to negotiate with the potential vendors of the other half interest. They came to an agreement of a fixed figure, which he refers to. And he says, sorry, I could not stay for the business end of the meeting. And this is really important because it was in effect put by both the judge and my learned friend to Mrs. Azhar that a lot of work had been done by Mr. Smethurst for which he wasn't going to get paid. And he'd attended this meeting for a number of hours. And why shouldn't he get paid on the basis of the commission for the offer? The error in that is that it's clear from the evidence that there was an appraisal fee of £1,995, not an insignificant sum, for him to look at and produce the figures to send out to the people who could lend money. Plus one thing, there was a stipulation. She said, I will agree this fee if Mr. Smethurst comes to the mediation meeting.
Now, we're getting a bit of a way away from the point of in the appeal, aren't we?
Sorry, I was going to, because I'm going to wrap, or I will do it. I simply say it there then, that that's the agreement that they rely on, but he wasn't there at the meeting to know what was done. He wasn't there at the business end. He was there earlier on, but not, as he says himself, business end. So, at the heart of the matter is the question of this particular clause. And we've got Mr. Stephen Skeleton. We've got the raising immediately by the judge within about 12 lines. I think, I mean, there are other examples. Page 143, the bundle. This is cross-examination by myself of Mr. Smethurst.
Yeah, and it's line 33.
Yes. And which reflects the terms of the confirmation instructions. Could you find me the letter, confirmation instructions letter? And then there's a passage down to line 25, where you'll find I hand wrote at the end of the fact-finding reference her instructions. Exactly what her instructions were, well, that's not right. So there's a handwritten letter from the client in the end of the fact-finding. I'm looking for a confirmation instruction. Do you have a document called confirmation instructions? We have this confirmation of instructions since the engagement, and we have an application form, and we have emails, and we have further instructions. You see confirmation instructions in Schedule 3 on page 40, something completely different. That's for the application. And the judge, what are you looking at now? Page 40, there's something in Schedule 3 of the agreement called confirmation instructions, but it's obviously not a letter from the client. There is no letter. This is the confirmation of instructions section of the engagement form. The engagement form is a different form. Where does she set out in letter form to you, in capital letters, confirmation instructions, so section to you? There's no specific letter. There's no specific letter. There's no specific letter, but this is part of the agreement, right? My instructions were confirmed, but etc. So, cross-examination, the point is raised. Is there a confirmation instructions letter? Answer, no, there isn't. I hope I'm not transgressing again, but could I just refer to page 107 just for a sec?
100 and?
Page 107 of the bundle.
Yes.
And that is line 28. This is on the point, sorry, I just think it should fit in here. This is on the point that they say that there was a variation of the instructions and that the final instruction is at page 66, and that's the letter I referred to after the meeting, where he says, sorry, I couldn't be there at the business end. So their case has been, in this case, well, confirmation of instructions letter doesn't really matter because you can read it from other documents and it was varied at the end. And this missive email on 30th of March is the final variation. I'm just trying to make sure that I don't. This is at page 60. This is the judgment of His Honour Judge Lewison.
Yes.
And he refers to a submission that my friend made. First instance, I'll stop at this point to address my learned friend's submissions on the need for a letter. There is no requirement for particular formality. Letter is not a capital letter, it's not a defined term. When one looks at or squints at what is said in page 21, you've got to ask yourself, well, what does it need to say? I want to buy the entire ownership of the freehold property. Well, that's all it's got to say. So here my friend in his submissions is addressing the point that there's no confirmation of instructions letter. And then at page 91. Now this is the original judgment. Now, paragraph 24. Now I pause to reflect also that what the defendant says is, in fact, you would not be entitled to payment in any event because you had not provided confirmation of instructions as is set out in your agreement. However, leaving that aside for a moment, what they say is, we told you we wanted 12 months for the bridging loan, and you produced a document for only 9 months. And then the final reference is on page 93.
This is paragraph 40.
It is, yes. And interestingly enough, what the judge says at the end of that paragraph, not perhaps worded terribly happily, but it is perfectly clear what she intended. She wanted a long-term loan, 10, 20 years, whatever she could get on reasonable terms. That's his reading from a particular perusal of whatever the documents were in relation to the agreement that he was looking at. Of course, that's not what the offer, in inverted commas, that's relied on is about. That's a bridging loan. This is not what she was sent at the end. And therein lies the vice of the confirmation of instructions letter. If there's no letter, then how are you going to judge? It's part of the contract. It's clear as crystal what it says. How are you going to judge whether an offer that entitles them to a fee has been arrived at? There's nothing. In effect, it leaves Mr. Smethurst to say, as he did in evidence, that it didn't really matter what the terms of the offer were. He was entitled to his fee, and it was put to him, because in that final document, there were 2 elements of commission, both of £27,400. There was only one in the first document. The one that they rely on, there were 2 elements of commission. And it was put to him that if the finance company put in any figure, 100,000, would he still be entitled to the fee? And his answer to that was yes. If he produces an offer, a financial offer, he did think it was a bit disingenuous to use a figure as excessive as 100,000. But his answer was he was entitled to his fee, whatever the terms of the offer, if it was a financial offer. It didn't matter that it was a proposal. It didn't matter that it was indicative terms. She simply had to pay. And we say that just simply isn't right. It just can't be right.
Well, that's a point you lost on, the indicative nature of the offer, and
Yes.
you don't have permission to appeal against that.
I don't. I think it would be remiss of me not to refer to it, because on occasion courts do take a different view of something, even though you haven't got leave to appeal on. But I don't want to. I want to tread very carefully on this, but it is. I have to refer to it if we go further on the arguments, because of what the email preceding it by about 4 hours said from Mr. Smethurst, and that was about raising 850,000, 12 months interest, and then going on to say we could, that he had a valuation of 1.5 million, again going on to say we could put in a valuation of 1.9 million and get a higher offer, which would have given more commission, of course, and that's what they did. But the initial thing is, presumably based on a telephone com with her when she told him what had happened, 850,000 at a 12-month period. What comes in 4 hours later? It's not that. It's 9 months, 3 to 9 months. It's a bigger sum, and the interest rate is 0.99%. Which is more than the 7.9% that was listed on the 2 offers in principle that she was sent by him before Christmas for the long-term mortgages. That was 7.9%. And the 0.79%.
Sorry, where are we going with this, Mr. Thrower? Are you making these submissions to stress the importance of the confirmation letter?
Yes.
Or, well, all right.
I also anticipate having to deal with my
I
friend.
wondered whether you were also dealing with the points that Mr. Stevens has raised.
Yes,
in
I
his
don't know
response.
whether you want to deal with this point first.
I don't mind, but I'd just like to know which points you're dealing with.
Yes, yes. I think on the terms of the new point, it's quite clear that it was raised, dealt with, and a judgment given. Given the circumstances, it submitted it would be incredibly penal on somebody who at that stage was a litigant in person to have a point thrown out.
Which stage was she a litigant in person?
Until very recently, in fact, for the first trial and for the first appeal.
Well, I thought you appeared.
Oh, sorry.
You appeared for her at the
Yes,
first trial.
yes,
And you put in a skeleton argument.
I did. Yes, I didn't want to mislead you on that. But
We don't know when the skeleton argument was
Yes,
produced, but it was presumably before trial or at the beginning of the trial.
no, I represented her. That's absolutely right.
Yes.
Yes, you were making a point that it was unfair on her
Yes.
when she was a litigant in person.
Well, I should then say when she wasn't represented by solicitor. She had a counsel, direct access counsel, but she didn't have a.
So you were instructed solely for the hearing before the Deputy District Judge, is that right?
Yes. And then I carried on with.
And then you carried on at the appeal.
Yes.
Yes. But she had put her own defence in. She was acting in person when she put her defence in and her witness statement.
I think so. I can't recall whether I gave any advice in a conference about how she should approach it. I don't want to mislead anybody. But that.
Well, her pleaded defence looks as though it's homemade.
Yeah. So let me come back from
I'm sorry, I
saying that
interrupted
she
you.
was a litigated person.
You said it was incredibly penal,
Yes.
and I haven't quite understood what was incredibly penal. at a stage at which she was acting in person.
Well, what I would say, let me rephrase it then, that given that the reason that the case proceeded after the amendment was in the, we say, in the interests of justice, to save costs, there was no specific pleading in relation to the right to commission, no reference to the clause on which it was based, which had to be the confirmation of instructions letter clause. The matter was dealt with from the start by initiated by the judge asking about it. You've seen the way in which it was developed and the judgment. It said that it's a new point in terms of the appeal, but this in effect was a point of law, not a point of fact. And I think this was picked up by Mrs. Justice Andrews in her leave to appeal decision.
Well, yes, it is, in the sense that it is a question of interpretation of the agreement,
Yes.
but there may be factual issues which outflank the legal point, which are the issues that Mr. Stevens wants to raise, namely waiver and or estoppel, which are factual matters.
Yes. But those weren't even raised at the first appeal. They've only surfaced recently. So
I think at the first appeal, we haven't got Mr. Stevens' skeleton argument for the first appeal, as far as I know. But the judge records that he did submit that were the point to be investigated, there would be further evidence that would need to be called, including further emails and conversations between the parties.
Yes, I mean, the difficulty with that is that it's rather like the assertion of estoppel by convention. In fact, it's rather like the claim in the first instance that there are no particulars, no real particulars. There's been disclosure. All the emails should have been disclosed. What other emails?
Well, that depends on what's in issue.
Yes.
And what was in issue on the pleadings did not include this confirmation of instructions point. It wasn't, so far as I can see, something that was raised by your skeleton argument in front of the Deputy District Judge. It arose in response to questions from the Deputy District Judge, and it may well be that the case changed quite dramatically after the particulars of claim were amended, but that didn't alter the points that appeared to be an issue.
But yes, I mean, my answer to that would be that when we turned up in court, the issues on the claim form were completely unwinnable. There was an allegation that wasn't true, that she'd accepted an offer effectively procured by Mr. Smethurst's company, and then they amended to say, well, we're entitled to commission because we procured an offer. Now that has to, if it's a particularised, has to include something about it complying with the terms of finance of the confirmation instructions letter. That's the basic definition. There's nothing of that. It was just simply 3 or 4 words and 2 sentences. And then the question came up whether we should go ahead or not. And the answer was, it was decided we should go ahead. I don't want to go into it, but it was sort of a bit of the judge and a bit of myself saying, well, I think he agreed with the sentiment. And I think that's part of my, what I said before, is that it seemed to be completely the right thing to do in the interests of justice, in accordance with the overriding objective. Now, this is all the making of the claimant. They have put in a claim that is not true. They have amended with barely a detail not even saying what document they were relying on, what terms. It's simply that basic. And to prove their case, they would have to show that they had achieved what the contract demanded. In other words, terms that complied with confirmation instructions letter. If a defendant is in effect told, well, you can't rely on the principle that a claimant can prove his case, it would seem to be an extraordinary state of affairs, given that we're talking about justice here. And we say that would be wrong. The question of whether or not the issue was raised and debated can only be answered, yes, it was. Is there a definition of new point that says you can argue the point, you can have a decision on it, but then if you want to have a go again, I'm afraid that was it's a new point not taken and you can't have the result you want. I'm having difficulty. What I don't say is it would be extraordinary if the Mrs. Azhar was not able to rely on the point she got leave to appeal on, when there was even a judgment at the end that decided. Mr. Smethurst admitted it in his cross-examination. He admitted there wasn't one. Where would the principle of the plaintiff proving his case go? It would simply disappear. I think the problem, I think maybe this applies to something later on, potentially later on as well. But this sort of case, the sort of arguments that are being put forward here, any decision must really apply across the board. That's what we submit. So, for example, if he's right, my friend is right, that any old offer will do, then it's carte blanche for any lender to simply put in the terms that were put in this document and turn up with anything and say, I'm entitled to commission. I think Mr. Smethurst, if I recall, was of the view that he could have claimed commission for the 2 so-called offers before Christmas, but I don't think that was more than just a passing reference, and that wasn't pursued. But on this basic point, we say that it's clear that the point was raised, and in any event, in the interests of justice, it should have been allowed to be proceeded with. I'm not sure from my friend's skeleton argument I need to address you in terms of the judge's reliance on a particular provision of the rules that related to factual
This
issues.
is the Rule 16(5) point, yeah.
That related to factual issues, not to questions of law. They hadn't set out their case in any proper pleaded form to be answered. And we should say that it was wrong to, if he did rely on it, my friend says he didn't rely on it that much or something to that effect. We say that was wrong.
Yeah.
I've set that out in my skeleton. Do you want me to go further at this stage and deal with his notice of respondents?
Up to you. You can if you wish, or you can wait for Mr. Stevens to advance his case. So it's up to you.
Yes, perhaps I can do it. I'll try and do it very quickly so that he knows where I'm going. I would say this, that in this case, for the outcome that occurred at that first instance was in effect saying a number of things don't matter. And it's very well to have investigations of factual matrices and consensual assumptions, etc., etc. But if one looks at this case, what happened, for the claimants to have won, it's effectively ignoring a number of what we say are important factors. And they're important in terms of looking at the equity. Was there any injustice or anything inequitable about the claimant not being able to recover if we went on the first point? Part of the estoppel by convention, which is in the cases my friend quoted, there's got to be a common assumption that's been communicated, effectively relied on by the party who's seeking to enforce an estoppel. But as in all equitable principles, it must be inequitable or unjust for the claimant not to get his money. And we say that these points are relevant to that. We have to ignore the fact that there was no letter of confirmation of instructions, which we say was a fundamental term relating to remuneration. Forget about the nature of the so-called offer, which was indicative terms. I think what makes it even more difficult here is that it's not even sure what happened to the first indicative offer, because it's only addressed to Priya and to one or two other people, Priya being the intermediary who apparently worked for a bank, who was organising the go-between Mr. Smethurst and MT Finance. There's actually nothing in the documents that shows it being sent to my client. The second one, which came the day after the mediation meeting, definitely sent to my client. And that's without a doubt.
You say that there's nothing showing that the first one was sent to the client. I thought the district judge found that it had been relied on at the mediation.
Yes, well, I have a real problem with that, because that's what the district judge said. There's no evidence from anybody that actually says it was specifically relied on. But the judge refers to it as being relied on. But what we say about that is that she had 2 long-term offers from December the 2nd, which were 7.9% interest, procured by, in inverted commas, Mr. Smethurst. She had the offer she came to the table with. She came to Mr. Smethurst with an offer already for 0.75% for a 10-month bridging loan. And that was put to him in cross-examination, that he knew about the terms of that offer. And the company which got it from is actually explicitly referred to on the agreement on 2 pages, because there was what my friend calls an exclusivity clause. So she said, I'm dealing with these people, and it's written, handwritten on 2 pages, that Delta management are excluded from that particular clause. So she came to him with this offer for a short-term finance 7.75% per month, 10 months. So when we get to the meeting, why is an indicative offer for 0.99% for 3 to 9 months of any great persuasion compared to the 2 other offers, in inverted commas, and her own one from Delta Management that she already had?
Right, where is this point going?
Well, if you provide 2 offers, as he did on the 2nd of December, as an indication, and he says clearly in his evidence, twice in his evidence, these were provided to help her in her negotiations. This was before the contract was ever entered into, the agreement with him, with her. There is no question of her paying for these offers in principle. Why then?
But into which legal box are you putting this?
Well, it comes to...
Your confirmation of instructions letter, that's a question of
Yes.
interpretation of the contract. And the question is interpretation and or procedural, was it a new point? Understand that.
Yes.
It's now said against you, well, if you're right, both on being allowed to argue the point and on the interpretation of the contract, then we are entitled to rely on waiver and or estoppel.
Yes.
Are your submissions on these offers directed to either of those 2 issues? And if not, what are they directed to?
Yes. First of all, you've got to show a common assumption.
Yes.
And I don't understand how the case is put. I simply don't understand it. My friend has said very little about the hard issues of the bones of what he's saying. What is it that has been relied on? What is it? What is the detriment? There is nothing specific at this. It said that because she turned up at a meeting and relied on this first document, not the one that came the day after, the first one that came a few days before, in some way, this could be read as a waiver. I'm not even sure, but that may be what's being said. Secondly, when she got the second document, she rang up about whether it could be terminated early. Well, I don't know how it's put, but that simply can't be right to say that that's something that evidences a common assumption. Or the fact that she made an inquiry about a tax point on her solicitor's suggestion. If you say there is a common assumption, there has to be some evidence that the common assumption has been communicated and been relied on. But when one looks at the 2 offers that were made on the 2nd of December, why is it not the other way around? Why isn't she perfectly entitled to assume that this further indicative terms and the document afterwards are what he said he was doing, was providing her with an idea of what she could get to bolster her negotiations with the vendors. So if there's any assumption that you can read out of it, is that these were not matters giving rise to payments. She wasn't going to be sent a bill until out of the blue he said he was going to send the bill. So it goes to common assumption. What is the evidence of a common assumption here? An assumption that she would have to pay the money if she relied on a particular document? Well, that certainly wasn't the case with the 2 December documents, which predated the agreement, And if it's right that there's a common assumption because he's providing documents to help her negotiations, how then, after the first two are produced, does the agreement say finance offer is, if it complies with the confirmation instructions letter? There'd be no need to do that if he was entitled to payment simply by producing something to assist her in negotiations. So we say that there's no common assumption, certainly not on her side. If there's anything she could assume, is that these were other documents in the same chain to show that she had access to funds. But even worse than that, of course, she came with an offer that was better in terms than the ones with the indicative terms were peddling. And that one can see that Mr. Smethurst himself described in an email as incredibly cheap. And then went and rang up the CEO, as a result of which the offer terms were changed to more onerous terms. So that's what the point goes to. It goes to a common assumption. I mean, the difficulty with common assumption, of course, is that it started off as an objective test. I think the answer today is, looking at the authorities my friend has cited, that in terms it's now a subjective test. But perhaps in one or two areas it might still need the court to consider what objectively you would make of a particular fact situation, which all goes back to the fact that estoppel by convention is a rare beast and sometimes very difficult to comprehend. And we say it just simply isn't put clearly what it's about. And on the face of it, common assumption is not there, simply not there, and a very good reason why it shouldn't be there on her part. But perhaps I could lead on to there to the other half of the definition, which is there must be something unjust or inequitable in a detriment caused to, in this case, Mr. Smethurst's company. In my submission, when you look at the document relied on, which is the document the day after the mediation meeting, where is there any detriment? Caused by a question whether the terms could be ended early or the tax implications, when she then says, well, I'm waiting for the offer of 7.9% over 10 months, or whatever. That can't be relevant. So what is said to be the detriment? He sends this document along. She doesn't want it. She's got a better offer. What detriment does he suffer? Apart from the fact that he says, I'm entitled to my fees. Now, what we submit on that is it cannot be just or equitable for Mr. Smethurst to say that he's entitled to fees for producing a document that has worse terms than the two offers he put before and the one he was aware of through Delta Management that got noted on the agreement when he went to see, well, when they discussed the agreement. What is unjust or inequitable about a person who regards any terms, and I don't use that advisedly, because that's effectively what he said in his evidence. Any terms he produced, obviously they couldn't be completely nonsensical, but any terms he would entitle him to commission. That cannot be right. It cannot be just and equitable that Mr. Smethurst's company gets £27,400 for achieving not just nothing, for achieving a negative in terms of finance. And one other point that should be made here, which I think the judge may have been influenced. And certainly in cross-examination at one point, my friend put to Mrs. Azhar, what did she expect? Did she expect Mr. Smethurst to work for nothing? And the judge, certainly in his judgment, says, you know, this man spent time at a meeting and that's the tenor of it. The problem with that is that he was paid. There was an appraisal fee for £1,995 with only one condition applied, and that was that he attend the meeting.
Yes.
But he had to leave early to go up north, and he missed the business end. £1,995 is not it's a substantial sum of money. So he was paid to do work. The meeting wasn't that long after the agreement was entered into. So £1,995 seems to have gone not very far, considering that he came up with these two particular documents, one of which seemed to have been whistled up within 4 hours. So we say it's not right to approach it from the point of view that this was in some way recompense for the work he'd done. He got paid for the work he did. So if one asked a reasonable man on the Clapham omnibus what he thought about someone being paid for producing an offer that didn't even meet the one she had before and claiming £27,400, I'm not sure he'd be impressed. Whether that's a good argument or not, I don't know. But underlying a lot of the arguments is common sense. I mean, my friend's submissions, and I think the judge was somewhat with him on this, was, you know, common sense says you should try and make an agreement efficacious. But that's normally where there's some ambiguity, something that is unclear. Nothing unclear about this clause. It's clear as crystal. Finance offer has to comply with what's in the letter of instructions, and it's there for a very good reason. Mr. Smethurst's company, in their documentation, talk about their accreditation and effectively their standing and professional bodies. Of course, that any sort of professional body is going to want to be able to show that they've got instructions and they follow that instructions. There cannot ever be a situation you can normally envisage where someone instructs a finance broker to get them a worse offer than the one they've already got. And what is even more difficult to come to terms with is the fact that the two offers before Christmas were for long-term loans, not bridging loans. Far cheaper than the bridging loan finance. But for some reason, even though the judge said she wanted a long-term loan, that's what she went for, she somehow got persuaded that a bridging loan would be better. I've obviously forgotten that the two previous ones were actually much more suited to what she wanted and were cheaper. So it's not just the offer.
The judge finds that those couldn't be proceeded with because of her credit record. can't remember precisely.
I think what the judge, what was admitted is that Mr. Smethurst and her discussed the fact that her credit record wasn't brilliant.
I'm thinking of paragraphs 40 and following in the district judge's judgment. 40, he says she wanted a long-term loan, 10, 20 years, whatever she could get on reasonable terms. 41, he says, because of her credit experience, she would not be able to get that, and that would have been clear almost from the outset. And at 42, he says it's no good the defendant saying, blah, 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 if that was not achievable, and she accepted that it was not achievable. At 43, she says, I'm satisfied that it was not achievable. She knew it was not achievable in the short term. I read that as meaning, well, there may be these offers in December, but they couldn't be proceeded with because they wouldn't actually have been achievable.
Well, I don't know the answer to that. I mean, if they I can't remember when they first started dealing with each other. It was well before. It was before December. There's no
You've got
indication.
a finding. You've got a finding of fact by the district judge.
We have to proceed on the basis of the facts as found in the judgment, save insofar as they are
I understand.
appealed with permission.
Yes.
You are stuck with these factual findings. They seem to me, but tell me if this is wrong, to say the December 2016 long-term mortgage offers could not in fact have been put in place, and she knew that. That is, by the time you get to the March meeting.
Well, I'll have to accept that. I can't. I mean, the fact of the matter, they were obtained after he discussed with her, and they were obtained to produce at the meeting. But the problem is that when it came to the nitty-gritty of the meeting, what might have been relied on, he's not there. That's another aspect of this case, is he's gone. So he's not got evidence to show that it were relied on. The judge makes a decision, but there's nothing in the evidence when one goes through it that actually points in that direction.
Yeah, I mean, there is again a finding at 45 that
Yeah.
the first bridging loan offer was produced at the mediation meeting, was helpful to her in being able to reach a settlement. Again, that seems to be a finding of fact.
Yes, I mean, I have a problem with that because there's nothing in the evidence to for that to be.
Unless you've got permission to appeal against it,
I
Mr.
know.
Thrower, you're stuck with it.
I am, and unfortunately, I can't say anything different would have happened, but I didn't do the application for leave to appeal. Somebody else had to be called in at the last minute. But there we are. I'm stuck with that. But it still doesn't affect the fact that she was entitled to assume that she wasn't going to be charged for these sort of documents to be used at the mediation, or the fact that she had already got and disclosed the Delta Management organised finance, which were better terms than the terms that were in there. But in terms of the justice and the equity of it, we say that there is no cogent argument that it's just and equitable, that someone who achieves nothing, there's no, we say no acceptable offer, but there's no offer that matches what she already came with, and that it would not be inequitable or unjust for him not to recover any fees for that. And the importance of that, if she is liable for fees, anybody who is a lender can on the face of it.
Yeah, I think you've made this point.
And we say that judgments should be of universal application, principles should be universal, and it doesn't add up in this case. Now, I think at that stage, unless I can help any more.
Thank you very much, Mr. Thrower. Mr. Stevens.
Thank you, my lord. I will start by addressing the structure of my submissions today. I propose to take the points in this order, but if you wish me to deal with them in different order, of course I can. First will be the contract and the parties' conduct. The second will be to address the arguments deployed at trial. The third I've called why the judge was right for the reasons he gave.
So why the
judge was right.
the circuit judge?
Sorry, the Deputy District Judge was right. And other reasons why the judge was right. I will then address you briefly on the authorities I've put before the court. Have you and your colleagues had a chance to read those? Or to read the highlighted
Yes, but
paragraphs?
are you going to say that the circuit judge, or are you accepting that the circuit judge was wrong to say this was a new point and shouldn't be argued, or
Well,
are you
recall
saying
how-
he was right?
I'm saying he was right. This was a new point, and I'm going to be addressing that under the arguments at trial. That goes to that point.
Right, so arguments at trial then feeds into the way the circuit judge decided the first
Correct.
appeal.
Correct. I mean, the majority of Judge Lethem's reasoning goes to what happened at the lower
Yes,
court.
indeed, he looked at the transcript in some detail.
Exactly. Then have you and your colleagues managed to see the highlighted passages in the
Yes.
authorities? I'm very, very grateful. So I won't hopefully need to elaborate upon that at length. And then to say why the appeal should fail on any of three arguments, that is the construction argument adopted by the Deputy District Judge, or the matters that I've raised in the respondent's notice, which is that there was a waiver of strict terms if you find that the terms were not properly construed by the Deputy District Judge. And of course, Judge Lethem, of course, by way of parenthesis, I think he said, he would also have dismissed the substantive point on the same grounds. And then very briefly as to why a stopper by convention is established on the facts of this case.
Well, yes. The circuit judge dismissed the appeal because he refused to allow the point to be argued on the ground that it was a new point which of which you had not been given sufficient forewarning at trial.
Yes.
And having decided that he wouldn't allow that point to be argued, because it was the only point for which I can't remember the other judge's name, the first judge had given permission to appeal, the appeal had to fail. Now, are you defending that decision by the circuit judge before we get into any of the wider ramifications?
Of course, I am, my lord, yes.
Because if you are, that's where you need to go first.
Okay, let's start there. Let's start there. If we look, please, in your bundle, at page 85. And my lord, you've already referred to this document. This was the skeleton argument produced by my learned friend for trial. My recollection is these were exchanged the night before, for what it's worth. So the case was prepared on the back of what's said. And what is not here, well, let's look at what is here first, is at paragraph 6 on page 85. There's firstly a statement that she was asking for a mortgage, not a bridging loan. But as my lords, you've already noted, that was the initial position in December. But when Mr. Smedhurst ran an experience check, this is paragraph 9 of Deputy District Judge Arnold's judgment, she couldn't qualify for that. So that point didn't work. He took the point, lines 3, 4, 5, that the offers procured were not offers in any meaningful sense because they related to bridging loans and not conventional mortgages. And at paragraph 9, my own friend took a point on construction relating to the definition of the term "you." And you'll recall that Deputy District Judge Arnold said that that argument makes nonsense of the contract. What there is not in this in the skeleton, and what there was not in Mrs. Azhar's evidence, and what is not in the defence is the argument based on the absence of a letter, that the contract required a particular form that was not honoured. And what His Honour Judge Lethem looked to in, I think it's page 59 of your bundle, is what really was in issue at first instance. And at paragraph 46, I acknowledged, of course, that the issues were raised in closing submissions, but they'd not been dealt with at all during evidence. Neither had they been trailed, as I've indicated, by the witness statement or defence. And in his terms, he had to deal with the submission very much on the hoof. And it's important his approach to this matter to say this, that there was even then a degree of confusion, that what the parties were looking at in detail was whether there was a letter of confirmation of instructions, as opposed to other documents which comprised confirmation of instructions. The focus of that being on the letter, and so at paragraph 131 he deals with the matter somewhat on the hoof by saying this, and this is the paragraph that my learned friend read out this morning. I'll stop at this point to address my learned friend's submissions on the need for a letter. There is no requirement for particular formality. It's not a capital letter, it's not a defined term. When one looks at or squints at what's said on page 21, you've got to ask yourself, well, what does it need to say? I want to buy the entire ownership of the freehold property. Well, that's all it's got to say. And then His Honour Judge Lethem proceeds to say what's relevant in the present case is have the instructions changed from time to time. And in that respect, Mr. Stevens was taken to the cross-examination of Mr. Smithhurst. And the fact that he does indeed concede there was no letter of instruction. However, what he seems to say in that passage of cross-examination is only that there is no letter, and that he's relying upon the other documentary evidence in the form of a mortgage fact sheet and emails. And so Mr. Stevens argues that there was, during the course of the trial and right up to his closing submission, an ambiguity about the points that were being taken. So when my learned friend fails at trial, he then takes an attack on formality that was not in issue before Deputy District Judge Arnold. The letter, the sacrosanct letter point, was not made at first instance. And of course, as I think His Honour Judge Lethem also observes, that further evidence of different evidence would be required to look at whether the instructions were recorded or had to be recorded in a particular form. For example, it's quite clear that Mrs. Azhar's instructions changed over time because their needs changed over time. Now, the contract anticipates that. It's going to be a common occurrence in procuring finance offers for the purchase of property. And so oral instructions are valid. And oral instructions were given and oral instructions were acted upon. So the point taken on appeal that the absence of a letter is fatal, which is how my learned friend put it, was not the case he presented to the learned Deputy District Judge. The arguments about the extent to which AMM failed to act in accordance with her instructions was limited to a misconceived point that she only wanted mortgage finance. And you'll recall Deputy District Judge Arnold gives very short shrift to that argument, because when the second finance offer is procured, she doesn't say that doesn't fit with my instructions. She asks, how quickly can I pay off the bridging loan? So a different attack is taken on appeal than was taken at first instance. And so you asked, do I defend that judgment? I absolutely do. But it seemed to me in circumstances where Lady Justice Andrews granted permission to appeal on what I call the COI argument in any event, I would focus on that.
Well, I mean, the fact that Lady Justice Andrews granted permission to appeal doesn't or at least doesn't necessarily mean that you're disentitled from saying that the circuit judge was right to refuse permission to argue that point.
Absolutely. I took a more pragmatic approach, I think. I think I said even if it was wrong, the appeal is defeasible in other ways. I think that's how I did it. But it can be seen from Judge Lethem's careful and detailed analysis of what happened below, that this wasn't the focus of the attack. That the learned Deputy District Judge wasn't invited to determine the case or to decide the case on the basis of formality. And the construction argument that was before the court, we engaged with and we defeated it.
I hate to interrupt, could I just refer to paragraph 24 at page 91 of the bundle?
Yes.
Paragraph 4. Sorry, which paragraph? 24. I'm sorry, I'm not quite sure what you're indicating here.
I thought my friend was saying that I hadn't raised the point at all at first instance.
No, I think what he's saying is that the point, it wasn't clear that what there had to be was a confirmation of instructions letter. And what the district judge is saying is you hadn't provided confirmation of instructions without necessarily referring to a letter. I think that's the point.
I think that from the terms of the subsequent appeal, the fact is that the judge actually recorded there that what I was saying was that they weren't entitled to payment because they hadn't produced a confirmation of instructions letter, which is, anyway, I thought I should raise it.
I think I read out para 47 of His Honour Judge Lethem's judgment, where he talks about the degree of confusion. I think I already addressed that, my lord.
Yes.
And the distinction is between other documents that contain instructions and a letter, and what a letter must mean. It's a pure formality point, isn't it? It's a technical formality point. But the case at trial was that the instructions, in a broader sense, were not complied with because she didn't want a bridging loan. Well, that didn't work. Not that I can refuse to pay because you can't produce a letter. That's a different point. And if we know that point was going to be taken, waiver and estoppel would, of course, have been raised at first instance. We would also have prepared evidence as to, well, probably a timeline of instructions, how they changed over time. But you'll recall from the transcript of first instance that I took the learned Deputy District Judge to the instructions that were recorded in writing, because my case was they are the instructions upon which AMM acted initially, but her needs changed over time, and they continued to act in accordance with her instructions as varied. Now, if it would assist, my lord, I can take you to the documents that do comprise instructions in writing, but I know that my learned friend took you to the transcript where that's being discussed, but I'm happy to show you.
It's up to you.
Yeah, very, very briefly, if I may. Yes, if you look at 216, please, in your bundle.
This is the fact find.
Correct, exactly right. And on page 2 of the fact find, so 217 of your bundle, you will see there, admittedly.
Do we know the date of this document?
Yes, this is the 9th of February. My lord, let me just give you proof of that.
224 has got a date of 28th November 2016. Is that the same document?
Ah, yes, it might be. It might be.
Mr. Thrower told us that your client had been instrumental in procuring offers back in December 2016.
Well, I've never been quite clear as to what happened there, because it certainly wasn't under the terms of a contract. The first contract is entered into in February 2017. So I'm not quite sure what the history of the parties' dealings were before that. But what this document proves is that the essential purpose for which she was dealing with AMM at all is recorded in writing, and it's recorded in writing on page 217.
Mr. Smethurst's witness statement, 213, does say that he received the signed fact find on the 28th of November 2016. And as you say, the contract you rely on is not signed until February of next year.
Indeed. So it could be she obtained some assistance gratis as an indication of what may be available if she instructed them. I mean, I suppose that's probably what seems to have occurred. But when she enters into the written terms, it's on the basis of the same instructions for the same purpose as she acknowledged in writing in November 16. And it's 217, Manuel. You can see where it says at the top, commercial, remortgage, £1 million, purpose of loan to pay off partner. Well, those are the instructions that AMM procured offers in relation to. Not a mortgage, as you and your colleagues have seen, because she couldn't qualify for a mortgage. In fact, para 9 of Deputy District Judge Arnold's judgment confirms a little more about that. And it's, rereading that just now, I found the reference to the experience search. Because of her, well, sorry, probably start with 8. I heard from Mr. Smethurst, and what he said was that he thought he could help her to obtain.
Sorry, where are we now? We're back in the judgment.
I'm sorry, yes. So this is page 89, paras 8 and 9. Are you there, madam?
Yes.
I heard from Mr. Smethurst, and what he said was that he thought he could help her to obtain a loan. Initially, she says that she wanted, and I think this is accepted, a medium to long-term loan, 10, 15, 20 years, whatever, a commercial loan on the property. Because of her poor credit rating, arising according to Mrs. Azhar, and I accept what she says in this regard, from her divorce proceedings, the nature and extent of those, she was behind in making some payments with her mortgage or credit cards, or whatever. As a result, she had a low credit rating. This was established by Mr. Smethurst on behalf of the claimant from making an experience search, to which I have been referred. So the initial instructions, try and get me a mortgage, up to £1 million, pay off X partner, they changed. They had changed by the time the contract came to be concluded. But why, well, rhetorical question is why are those instructions not sufficient record in writing of what she wanted them to procure, albeit on a changed basis over time? The purpose of the transaction was the same. The approximate sum was the same. The property was identified. It's the same property she ends up acquiring, the second half of. Is that of no effect simply because it doesn't say it's a letter? If that had been my learned friend's submission below, sorry, at first instance, I would have said incredibly technical argument. It wasn't an argument that was articulated in those terms. There is ample evidence of the instructions being recorded in writing elsewhere. So, and of course, His Honour Judge Lethem says the underlying point would fail anyway, even if I had granted, even if I had acknowledged it wasn't a new point being raised on appeal. So it seems to me, and I'm rather out of my structure here now, my lord, but it seems to me that I would like to turn, if I may, to why the decision of the Deputy District Judge can be upheld on different reasons anyway. Yeah. And that really feeds into His Honour Judge Lethem's in parenthesis paragraph as to why the underlying COI argument is not a good one in any event. If I may please just take you through very briefly a review of the contract. It's not well drafted, but it's not obscure. If we start at 232, please. And over the page to 234, you will see the definition of lending proposal. And what it refers to is not a letter, in fact. It says confirmation of instructions. The proposal prepared by the broker, setting out the requirements, recording the confirmation instructions, provided in accordance with paragraph 1, as varied from time to time. Paragraph 1 of the attached terms and conditions as varied from time to time. Now, the definition of finance offer refers to a letter, a written offer containing.
Well, wait a minute. The confirmation of instructions, according to the definition, is provided in accordance with paragraph 1 of the attached terms and conditions, as
Yes.
varied from time to time.
Yes.
That's on page 236.
Yep.
And that tells us that before signing the agreement, the broker will complete a confirmation of instructions stroke application form,
Exactly.
which should be read and take effect as if they form part of the agreement. Now, is the application form, is that a fact find?
Exactly. Why is it not? But it doesn't use the word letter. I'm sorry to make what sounds like a similarly technical point, but there is no consistency in the term used, in fact. But what 1.1 anticipates, my lord, is something being done before the agreement is signed. Well, they did.
It also contemplates something being completed by the broker. Is the fact find completed by the broker?
I think that was Mr. Smethurst's evidence at trial. I think my learned friend took you to something about being handwritten. But again, my lord, that to suggest I don't have to pay because I don't have to pay because I filled something out rather than the broker would be similarly deeply unattractive. And most likely a waived condition, if indeed that was it. But that wasn't my learned friend's argument either. It's never been part of his case that something should have been completed by a broker as opposed to Mrs. Azhar. But my recollection is that Deputy District Judge Arnold found that that was part of the instructions, that it was completed. May I just find the reference? Handwritten is the phrase that I have in mind.
At page 240, there is a confirmation of instructions application form as part of the documentation.
Page 144, my lord. This is the evidence of Mr. Smethurst. And it says, you will find I handwrote at the end of the fact finding, reference her instructions, exactly
Sorry,
what
where
her
are you?
Sorry, 144, top of the page.
Yes.
You will find that I handwrote at the end of the fact finding, reference her instructions, exactly what her instructions were. So there's a handwritten letter from the client at the end of the fact finding. Slightly garbled, but what he's saying is it's completed. It's completed by hand. Learned Deputy District Judge finds, well, that's part of the instruction. Although he didn't elaborate, Judge Lethem, one would suspect, was of the same view, but didn't feel the need to elaborate upon his reasoning because he found it was a new point. Correctly so, my submission. So the terminology used in the contract is not nearly as black and white as my learned friend suggested. The terminology is rather fluid. The confirmation of instructions are in the nature of an application form. What is it you want us to do for you? And that needs to be recorded in writing. Well, it was. In fact, if you look at page 49, please, back in Judge Lethem's judgment. Paragraph 6. Well, I say he doesn't elaborate upon the reasoning, but I think a clue perhaps is to be found in paragraph 6. Now, the confirmation of instructions letter, this refers to the terms and conditions that are annexed to the agreement in paragraph 1. And it seems to me that although the wording of the agreement is very poor, and that there are at least 2 Schedule 3s contained in it, one of the Schedule 3s seems to me does contain confirmation of instructions and an application form. Over the page at 7, now as well as signing the contract to which I've referred, the defendant also signed a commercial finance declaration and terms and conditions. Annexed to that, there was a document which was entitled Schedule 1 Terms and Conditions. It set out various agreements as between the parties in terms of confirmation of instructions, the client's duties to broker, an introductory commission, and was certainly not in the form found in Schedule 3 to the original agreement. So what the learned judge below is saying is there were confirmation instructions in writing, and so the COI argument, even if it's not new, is not a good one. My next reference is 106.
In paragraph 7 of his judgment, when he says the defendant also signed a commercial finance declaration, is that the fact find you showed us?
No, I think that's a different document. I did bring along the initial Court of Appeal bundle. I don't know if you have that, because the bundle prepared by my learned friend doesn't include all of the evidence that was before.
I'm afraid that this is a bundle that was prepared by both parties with instructions from the court over a considerable period of time. It's not something that we have done out of a whim, leaving things out.
No,
it was done in accordance with court directions to produce a core bundle. Both firms that were involved.
I was not suggesting for a moment that you'd left anything out deliberately, merely that it wasn't in there.
There is a document at page 242 entitled Commercial Finance Declaration. And then there's
Yes.
another document after it called Terms and Conditions, which is also signed.
Yes, which also refers to confirmation of instructions and is signed by his Azhar.
Yes. Of course, there's also Schedule 3, which is 240. But the submission I'm making is that the contract was complied with, these terms were complied with. Putting to one side the fact that Mr. Thrower was not arguing that because a letter could not be produced, they were acting without instructions. That wasn't his case. It wasn't his case at all. It was that she wanted something different from what you procured. Not the same point at all. Because I could point to, and I did point the learned Deputy District Judge to, the written documents I've just shown you to say 1 million to buy out partner, this property. That's what I need. Those are her instructions. Those were the essential instructions that never changed. The only question that changed, or the only matter that changes, well, you can't do it by way of a mortgage. It has to be original, because you can't satisfy the eligibility requirement. And so they did what she wanted them to do. They did what she instructed them to do. But the contract, the dealings between the parties are broader than the narrow focus that is put by Mr. Thrower in this appeal. Because you and your colleagues will have noticed that there was also a valuation. So she instructed AMM to obtain a valuation to help her negotiate a settlement of the 50% equity in the property. Therefore, the amount she wanted to borrow, the amount she would need to borrow, could not be ascertained until that valuation was produced. When it was produced, the first finance offer is procured. My own friend was making a submission, I think, about the appraisal fee and whether that constituted absolutely everything that AMM did. Well, no, that can't be right. That's simply for preparing the papers to go to the lender. What triggers a different payment is the arrangement fee. And that comes with the procuring of a finance offer. And the learned Deputy District Judge found as a fact that 2 finance offers were procured. Now, the dates may be significant because the first one is procured more than a week before the meeting at which it was found the offer was tabled as a genuine offer of finance. So it would be impossible, my respectful submission, for a judge to find on that evidence that it was not in accordance with her instructions. Why else was she using it? Why did she not challenge it? This isn't what I want. This won't do the job. On the contrary, she takes it and she relies upon it. She relies upon it to persuade third parties, in fact, that she can afford the sum she was offering to pay. So, and also, of course, the terms of the agreement, poorly drafted as they are, anticipate these sort of eventualities. People's prices may change. People's requirements for funding may change. They may get some money, they may need less. They may not need as much as before. And in circumstances where the factual matrix includes, I don't really know what this property is worth yet, that has to be ascertained after valuation is obtained. And I certainly can't see anywhere in the evidence something in writing from her saying, go and get the evaluation. But I can show you an email, a text message from her, which she writes to Mr. Smethurst on the 20th of February, I think. Let me just find it.
This is 2017.
In 2017, correct. I'm terribly sorry, I can't find the reference at the moment. I may just find it. It's towards the back of the bundle. I don't know. Yes, here we are. 229 level. This is exchange of text messages between Mrs. Azhar and Mr. Smethurst. And if you turn the page, please, 230. Second message. Hi Wayne, did you speak to James? Have we got the valuation ready? So that is evidence that AMM and Mrs. Azhar are procuring valuation that is to be given to AMM, on which the offer to be procured will inevitably be based. And what we don't see again between the 27th and the 28th of March, 27th February and the 28th of March, is any suggestion that the offer that's procured on the 14th of March and tabled at the meeting was in any way inadequate or not in accord with her instructions. And what, on page 154 of your bundle, you can see is that Judge Arnold himself asked Mrs. Azhar questions about what it was she wanted AMM to do. And it's line 13 on page 154, where you can see the following exchange. The question you're being asked is whether this represented what you wanted to do. It may be complicated, it may have been difficult, even though presumably there may have been other things that had to be done. What you wanted was for the executives of Mr. Nazim Kazid to sell you their entire ownership of the freehold without a leasehold of 46 Camden High Street. Yes, this is basically a part of it, yes. Sorry, part of what? That I wanted them to sell the share. And there was a flat as well, Your Honour. So 46 Camden High Street was the whole property, was it not? Yes, shop and flat. And then he says, so you wanted them to sell you the freehold of 46 Camden High Street. Yes, and one of the leasehold flats, one of the flats in the lease as well. That is what is recorded in writing in the document that the learned Deputy District Judge finds comprises part of her instructions. But she confirmed that those were her instructions, those were her oral instructions as well. And in fact, it is what they did. If you look, please, at 159, we're still in the the discussion while evidence is being taken. And Mrs. Azhar says at the very top, I asked him to do something and in return I would have paid him. But I don't understand why I'm here today. Because you haven't paid is what is put to her. She says he doesn't deserve to be paid. He didn't do what I asked him to do. What do you reckon he should have done? I asked him to get me a loan. Well, that was what they did. They got an offer of finance that the learned Deputy District Judge found satisfied the definitions in the contract.
Well, no, her case there was she wanted a long-term loan,
A
not
mortgage.
not
Correct.
a bridging loan.
Exactly right. Exactly right. But that was rejected. Para 25, I think it is, of Deputy District Judge Arnold's judgment. Let's just look at it because in my submission it is important. Page 90. 88 it starts. Yes, here we are. It is it's paragraph 25, page 91. Actually, let's do 24. Now, I pause to reflect also that what the defendant says, in fact, you would not be entitled to pay him to any event because you've not provided confirmation of instructions as set out in your agreement. However, leaving that to aside for one moment, what they say is, we told you we wanted 12 months for the bridging loan, and you produced a document for only 9 months. What the claimant says is that is not what the defendant wanted, and they rely, apart from any other matter in that regard, to an email that was sent by the defendant after she had received that offer. This said in terms not that she was unhappy, because it was not the type of loan she wanted, but that she was concerned to ensure she could repay it early. In addition, there would be no additional penalty to pay by paying it early.
Do we have that email?
I brought it along, my lord. That's one of the emails that is missing, unfortunately, from this one. May I just find it? Page reference.
You also got the district judge's findings at, which we've already looked at 41 to 45.
Indeed. May I hand this up?
What are you handing up?
This is the email that the learned Deputy District Judge is referring to in paragraph 25. We were just looking at.
Have you given a copy to Mr. Thrower?
I've given him a copy of the entire initial appeal letter.
You've got 3 copies?
I do. And it's page 104, my lord.
Page
104
of this new bundle?
of the new bundle. And this is, you'll recall...
Mr. Thrower, is there any objection to our looking at this?
as I say, my lord, this was Mr. Thrower's initial appeal bundle, filed with the Court of Appeal.
No, wait a minute. It's about to fall apart.
Oh, I'm sorry.
You say the initial appeal bundle. This is a bundle that was before the circuit judge, is that what you're saying?
No, the Court of Appeal, as I understand it.
Oh, this is the bundle for this appeal. Yeah.
Let me double check, I believe so. This is what I was responding to in the initial submission. It's 7th December 21. Yes, I think this is the initial appeal bundle. So 104, you can see at the bottom there, the date and time of the email. Uh, 29th March 17, right at the bottom, Marlon. At 1:25, Rahana Azhar wrote, Wayne, if I wanted to pay early, does the bridging charge me for the months I have it for? or do I have to pay for the full 9 months? What she is responding to is the second finance offer procured after her needs changed following the mediation meeting. She writes it within an hour, less than an hour, of receiving that offer, which you see on just below it. As promised is a phrase I may return to. The maximum facility offer has been procured by PRIA, subject to the new valuation. This should be more than enough, but the sooner we instruct a new survey, the better. So this is a piece of evidence that was fatal to the real argument that Mrs. Azhar and Mr. Thoreau were expounding on at trial, which is, I wanted a mortgage, and you got me a bridging loan. Well, you knew it was a bridging loan. You asked if you could pay it off quickly. So the issue and the ambiguity in the issues being taken or the points being taken at trial is really exemplified here, because the suggestion is not that there's nothing in writing to say a bridging offer is fine. In fact, the argument is not that needed to be in writing at all. The argument was, you got me something I didn't want. But in fact, that's not right. They did. They did it twice. Page 34 in your, if you could put that bundle to one side, please. Page 34 in your main bundle. Confirms that there was other written records, or there was another written record of her instructions. And it's a document that my learned friend has actually relied upon. Paragraph 8, he's quoting from an email in which she says, I must obtain independent valuation from a reputable firm to help in the roundtable meeting for a buyout offer to the ex-business partner, subject to a reasonable interest rate and terms and conditions for up to £1 million loan. Well, that could be confirmation of instructions. That could be confirmation of varied instructions. It's in writing. How can she say they weren't acting on her instructions when she set them out so clearly in writing? That is exactly what they did. And as you can see, what this is all building up to is alternative means of deciding the case, not that Deputy District Judge Arnold referred to waiver or estoppel, but it seems that both he and His Honour Judge Lethem had those principles in mind, because Deputy District Judge Arnold referred to it, not laying very nicely in her words, to say that an offer she'd told a third party was a genuine offer wasn't a finance offer at all.
These references, this is your skeleton argument for the appeal.
Where are you quoting from, Alan?
Page 34, you're reading this.
Oh, I'm sorry. Yes, you're right. You're absolutely right.
What are the numbers referred to in brown brackets?
That'll be this bundle.
This
That's
one.
what I was going to ask. Those numbers don't correspond.
No.
What you refer to as your original appeal bundle, which is probably more accurately referred to as a draft appeal bundle.
Yes.
That is never in fact filed as such.
Well, I think it was filed. It looks like it's certainly
Right.
stamped, and it's the bundle I relied upon when feeding the skeleton out.
Yeah, that explains why the numbers don't correspond to what's in our bundle.
So you will find that at page 78 of the initial bundle. We call it this. And so the point I was making was that even if not in express terms, the issues of whether the parties proceeded to deliver the services and to request the services that ANM in fact delivered, they did so without requiring adherence to the strict letter of a contract, if indeed a letter is required. Because, I don't want to repeat myself, but they did what they were contracted to do.
So this is the 9th of February 2017.
Yes, same day as the contract is signed.
Same day as the contract.
Correct. So could that be confirmation of instructions letter? Might be, could be. But because the point wasn't taken at first instance, those arguments are not to be found in the transcript. What you'll recall is, I said, the instructions are to be found in various places, in writing.
Yeah.
Which I suppose Mr. Thoreau could then have said, but that's not a letter. But that's not the point he took. It wasn't about the formalities.
Can I be sure I understand your case? The email you've just shown us from the 9th of February 2017 refers to up to £1 million loan, and that's consistent with the fact find backed in November, which had a figure of £1 million.
Exactly right.
And the offer that was in fact procured on the 14th, I think, of March was for 850,000?
Was within that tolerance, yes. But that was in light of the valuation evidence obtained.
Yes,
I think they didn't need as much as...
As I think is common ground, it was in Mrs. Azhar's interest at that stage to have a low valuation, which would drive a low mortgage or bridging loan offer, in order to put in front of the counterparty to the negotiations and persuade them that the property wasn't really worth very much.
Right.
But after the meeting, which took place on the 28th of March, and at which I think agreement was reached on a purchase price for the freehold, but not perhaps the leasehold. The next day, the offer you produce is 1.235, and that's the one you actually sue on. Where are her instructions to procure an offer for more than £1 million? What is it you say, as a matter of fact, happened to change those instructions? I have your point that instructions can be changed orally and so on, but what is your case as to what the instructions were?
Yes, I submit it as to be found, the answers to be found on page 266. 266, my lord, of the real appeal bundle.
Of the main bundle.
The main bundle, yes. Now, again, a point that's taken against me that actually assists me for my submission. Mr. Smethurst was not there at the very death, was not there for the final negotiations. But he was in...
I think there was evidence he stayed for some 6 hours.
6 hours, correct.
But then had to go back to Manchester, which is where he lives.
Yeah, exactly. So he doesn't know the settlement figure. Settlement figure is something that he's informed about the following day. And the need to procure, and this is why I emphasise as promised.
So this is very early in the morning, the next day. He must have spoken to or had some email we haven't seen telling him what the outcome of the meeting was.
Exactly right.
He says, sounds like the day ended quite late, but with a resolution.
Yeah.
So someone's told him something. What is the evidence? What is your case as to what happened?
Well, a higher amount is needed to satisfy the settlement sum.
Right.
So a new finance offer is needed.
Was this explored in evidence?
Precisely what are you referring to, Mike? How the second one came to be procured?
Yes.
No.
What her instructions were?
Yeah, there are 2 points. The first is, there was no attack on that. My learned friend did not say, that needs to be in writing, which is the COI letter, the point on which he has permission to argue here. But the second point is, and as the judge found in para 25, it obviously cohered with her instructions because she asks, can I repay it earlier? She doesn't come back to say, this isn't what I want at all.
Yes, she doesn't come back and say, what are you doing getting
Exactly,
an offer at 1.2 million?
Exactly right.
I don't want more than £1 million.
Exactly. She acknowledges that her needs have changed. She is exploring how this can be redeemed. So there was no express evidence called in relation to the instructions because that wasn't the focus of the argument at trial. The focus of the argument at trial, as I've said, is mortgage or bridging, and that was just plain wrong. But clearly, if the attack was on, was that an offer in accordance with her varied instructions? We would have explored it more, and the answer would be, of course it is. Look, and this backs it up, because she doesn't come back to say, I don't want this. She comes back exploring the terms of it.
And that's the point the district judge made, isn't it?
Exactly right.
Not quite, he didn't go into all the figures, but that's the point that he was
Exactly.
making, I think.
Let me find you the reference.
It's paragraph 26, isn't it? Page 91.
This came after the email, yes. That's where it is. Not much more than an hour later, in which she says, if I wanted to pay early, does this bridging charge me for the months I had it for, or do I have to pay for the full 9 months? This email came after the email timed at 12:40, which said, as promised, a maximum facility offer has been procured. So she's asked for a maximum facility offer. I mean, that's confirmation of those changed instructions. Subject to the new valuation. She's told them about the valuation, the increased valuation agreed upon. This should be more than enough, but sooner we instructed you to the survey, the better. I paused to reflect that what had occurred was at the mediation meeting the day before, at which Mr. Smithhurst said, and this was not disputed by Mrs. Azhar, he was there for 6 hours. Property was valued by the other partner, the other co-owner, at 1.9 million, not the 1.5, or whatever it had been valued at, by Ord, Camel and Critzley. The second finance offer is procured at her request upon changed instructions for the same purpose as they've been dealing since November 2016. And she can, as my lord has just noted, and those instructions did not always have to be recorded in writing. They can be varied orally from time to time, which is exactly what happened here. So provided there is something in writing somewhere, this is my submission, to confirm the instructions on which they proceed, that is sufficient to constitute written confirmation of instructions. And there are abundant pieces of evidence in writing that go to show AMM did exactly what she wanted it to do. In fact, it did it twice. Now, is there anything else on the evidential findings that I can address you on that would assist you with the matters under appeal?
It's up to you, Mr. Thompson, Mr. Stevens, what you address us on. So if you want to take us through anything else, please do. If you think you've done enough, then move on.
I think those are the points I wish to make.
Right.
Now, why was the judge right? Why was the Deputy District Judge right? Now we'll look at Judge Lethem. Why was the Deputy District Judge right? Because he construed the written terms of the contract with good business sense against the admissible factual matrix. You probably still have open, my lord, page 91, and paragraph 29 shows that he acknowledged, my job is to interpret the contract that was entered into between the parties and then decide whether the conditions that were within the contract for the payment of monies to the claimant have been fulfilled. Para 30, he's got having regard to the context. Para 32, in construing a contract, the court will look at the natural and ordinary meanings of the words and as to what a reasonable person with all the background and knowledge reasonably available to him would understand the contract to mean. A common sense approach is adopted by a court in construction to give business effect to what was clearly intended. Furthermore, an objective view is taken of a reasonable person, given the context of the transaction. He did not adopt the sacrosanct view of letter because it wasn't argued that it was sacrosanct. What he did was he construed the words that were garbled in a proper objective sense, having regard to the factual matrix, which was parties know what she's looking for, they know what she can't get because she can't qualify for it, but they will do what she wants them to procure a conservative offer, and then an offer that will in fact hit the settlement sum negotiated at the mediation. So on the question of construction, he came to the right conclusion because the the instructions were perfectly clear. It's paragraph 40. In my judgment, there was no confirmation instructions letter, but what the defendant wanted was perfectly clear. She went to the claimant for him to try to obtain a loan. All that is clear, both within the terms of the documents to which I've been referred, and in particular, I was referred to page 21 of the bundle. Furthermore, this forms part of the fact find, so although Deputy District Judge Arnold initially said, well, a fact find isn't instructions, he came to the conclusion that on the facts of this case, which of course didn't involve regulated lending, it did form part of the confirmation instructions. This forms part of the fact find when it says, I've asked the executives of Ms. Nazim, because I've read this paragraph before. So his finding, the core of the finding is that the instructions, as I submitted, are to be found in documents, just not in the form of a letter. And the letter doesn't matter. The application form, the fact find, they are in writing. Paragraph 44, he rejects what was the battle point in the trial. I'm satisfied that she knew the offers that were being made were for bridging loans. I'm satisfied also that the bridging loan, the first of those, was in fact produced at the mediation meeting and was helpful to her being able to reach a settlement. To go back to my lord's point, if she'd managed to negotiate on the back of the valuation 1.5, that offer would have been sufficient. So insofar as you are querying whether it ceased to be of relevance, I'm not sure if my lord, that's what we were interrogating there. Or was
No,
it merely...
You're not suing on the 14th of March offer. You're suing on the 29th of March offer.
Indeed, but...
So my query was, we know what she wanted the 14th of March offer for and what she used it for according to the findings in this part of the judgment. What was your case? The question I asked you was, what was your case as to whether the 29th March offer, which is the one you're suing on, was in accordance with her instructions? And your answer was, look at the email at 7:49 a.m. the next morning from Mr. Smethurst, which demonstrates what he understood he was to do, and her response 4 hours later, which did not take issue with that, but raised a query on the redemption penalties, the early redemption penalties.
And the inferences that can be unpacked from that. Yes.
So I think I have your answer to what your case was, which is that the 29th March letter was also in accordance with her instructions, even though you cannot point to anything in writing from her on the morning of the 29th of March.
Correct. And so, standing back from the decision at first instance, what is found is what she wanted was clear, and they did what she wanted. They acted in accordance with her instructions, as recorded in documents and as expressed orally. Well, that is, my respectful submission, absolutely fine a rationale for upholding the judgment in and of itself. We'll look very, very quickly at page 44, which I know you've read with care, and that analyses the issue about the new point in considerable detail by reference to what happened below.
Sorry, which page?
I'm sorry, 44, my lord. Should be the beginning.
This is the order. This is Master Bancroft's order.
No, I'm sorry. I'm maybe in the wrong bundle, sorry. I'm looking for Judge Lethem's order.
Which paragraph is this?
Yes, 48.
Of
48 is page 48, my lady. Sorry.
That's when Judge Lethem's judgment starts.
Yes, exactly. Sorry, I had the wrong reference.
Paragraph 48 is...
No, sorry, my lady. 48 is the first page
yeah.
of the judgment. And page 49, paragraph 6, I've already taken you to. Sorry for making the same point, but it's in a different context.
Yes.
Where he identifies what the judge identified, which is confirmation of instructions is incorporated into the contract. Paragraph 7, I've already taken you to, but it's the same point in a slightly different context. What the learned judge below said, paragraph 9, it seems that the parties subsequently agreed to buy out at the sum of 910, and that the appellant had at that time a document which may have been indicative of an offer, but certainly the trial judge found was put forward as an offer of a mortgage. What I think the judge meant to say there was a finance offer, because that was Deputy District Judge Arnold's finding. So although it appears that His Honour Judge Lethem deals extremely briefly with the underlying merits of the COI argument, he does in fact deal with it in an adequate way for you to be satisfied, for you all to be satisfied, that it's a safe conclusion. That even if he hadn't found that it was a new point, he would have dismissed it anyway. And if one looks carefully at those paragraphs where he is discussing what happened below, you can see that is why he comes to that conclusion in paragraph 7.
So, I mean, what he identifies as being the point that Mr. Thrower wanted to argue, I think is in paras 19 and 20 of his judgment. That is to say, no letter.
Yes. Yes. But that is a new point for the reasons I hope I've explained. That wasn't his submission.
Yeah.
No letter, no payment was not his argument. His argument was, I wanted something, I wanted A, and you gave me B. Okay, so it is a different point. And it's really perhaps clearest at the very end of His Honour Judge Lethem's judgment that the new point is the tight and focused analysis of the contract. That's para 69. Para 69 of His Honour Judge Lethem's judgment. And you will not have seen anywhere in his skeleton, in the evidence, in the defence, in the witness statement, the tight and focused analysis of the contract that he is raising on appeal. But para 70, and I couldn't find my skeleton either, my lord, I'm very sorry. And they changed solicitors, so we couldn't obtain it. But from recollection, I'll be corrected if I'm wrong, what I was submitting in para 15 of my skeleton was simply the good business sense construction. Look at it in context. Look at what else can be taken into account. It would have been that case law, the case law and investors' compensation case law. And so what he's saying at 70 is, I think the construction argument works as well. That's what 70 is really directed to. When he says, Deputy District Judge Arnold in fact conducted himself entirely in accordance with those authorities in construing the business relationship in the round, and although not saying the parties dispensed with the need for a letter if indeed one was needed at all, he says that it's perfectly clear what they wanted, what she wanted, and they did it in accordance with the contract. I will address you briefly, if I may, on the authorities that I've placed before the court.
So just before you come on to authorities, which are all about waiver and estoppel,
Yep.
what do you say to the argument that the tightly focused analysis of the contract is only a question of law?
No, it's not only a question of law, because the contract, the finding is a mixed question, because it depends also on the facts of the circumstance in which it was created. And the parties' intentions viewed objectively are not merely on the words used in the contract. So it's not a pure question of law. And indeed, that's not how Deputy District Judge Arnold approached it, nor how His Honour Judge Lethem approached it. So I say that's not correct. As I say, very, very briefly, if I may, on the law, quite interestingly.
Again, just before you come
Of
to
course,
that,
of course.
there's one other point that Mr. Trent before us, which is this. Look at the offer you get on the 29th of March. It not only includes 2%, 24,700 for you, but another 2% for somebody else. And he said that Mr. Smethurst said that didn't matter, and it wouldn't have mattered if it had said 100,000. In other words, it doesn't matter how unreasonable the terms are, it's still an offer, and she has to pay you quite a lot of money for something that's no use to her.
The short answer, I think, is this. It doesn't matter what he thinks the contract means. What matters is what the Deputy District Judge thought it meant, and whether the finance offer procured was a finance offer under the contract. So he
was the finance offer containing two separate 2% commissions, which comes out of her advance, one which complied with her instructions.
I would respectfully submit that that's not the appeal, that's not this appeal. He's not attacked, was that a finance offer? And that is a finding that is undisturbed hitherto.
Well,
So although-
as I understood it, the way he sought to deploy it was, you need to have a confirmation of instructions letter setting out in black and white what her instructions are, precisely because it avoids any argument as to whether the offer complies with the instructions or not.
Yes.
And hence the need for the importance of having it in writing.
But not everything in writing. And the contract anticipates things will change, instructions will be given verbally at short notice in circumstances as they were here. So although that could be an attack, that's not this attack.
That wasn't the attack that was put before.
Not at the time, nor on appeal.
Thank you.
Is there anything else I can address you on before turning briefly to the authorities? I'm very good. They group into three because they deal with three issues. George on High deals with contractual interpretation, as well as the application of the principles of estoppel by convention. Do you have? I'm very good. Tinkler is, of course, the most recent authority, Supreme Court authority on estoppel by convention, and Bricom Investments deals with the question of waiver. It may be best if I take them in reverse order, in fact. So if we start at Bricom, please.
Starting at?
Bricom,
Yeah.
the third authority. Bricom and Carr reported 1979 1QB at the 467 decision of Master of Laws Lord Denning, and then Lord Justice Roskill and Cumming Bruce. It's not Lord Denning's dicta I rely upon. Lord Justice Roskill is very clear in this case that he doesn't decide the case based on promissory estoppel at all. What he prefers to draw upon is the learning in relation to contractual variation. I've highlighted the passages I wish to draw to your attention. Page 489 of the judgment. What I've highlighted here, I couldn't highlight every line, for some reason the PDF wouldn't do it, but I think it necessary to go no further than what Lord Cairns, Lord Chancellor, said in Hughes and Metropolitan Railway, 2 Appeal Cases 439, where the matter was put not as one of promissory estoppel, but as a matter of contract law or equity, call it what you will. It was not argued at your Lordship's bar, and could not be argued, that there was any right of a court of equity, or any practice of a court of equity, to give relief in cases of this kind by way of mercy, or by way merely of saving property from forfeiture. But it is the first principle upon which all courts of equity proceed, that if parties who have entered into definite and distinct terms, involving certain legal results, certain penalties or legal forfeiture, afterwards by their own acts or with their own consent, enter upon a course of negotiation which has the effect of leading one of the parties to suppose that the strict rights arising under the contract will not be enforced, or will be kept in suspense or held in abeyance, the person who otherwise might have enforced those rights will not be allowed to enforce them, for it would be inequitable, having regard to the dealings which have thus taken place between the parties. For my own part, I would respectfully prefer to regard that as an illustration of contractual variation of strict contractual rights. But it could equally well be put in illustration of equity, relieving from the consequences of strict adherence to the letter of the lease. But whichever is the right way of putting it, ever since Hughes, through a long line of cases, of which there are many examples in the books, one finds that where parties have made a contract which provides one thing, and where, by a subsequent course of dealing, the parties have worked that contract out in such a way that one party leads the other to believe that the strict rights under that contract will not be adhered to, the courts will not allow that party who has led the other to think the strict rights will not be adhered to suddenly to seek to enforce those strict rights against him. So one views objectively the, what's the phrase here? It's the way in which the parties worked out the contract, how it's worked through, maybe another way of putting it. And in this case, there was a course of dealing over 3 months, no, 4 months if one starts in the back end of 2016, where she was giving instructions to achieve a certain purpose, and they continued to act in accordance with those instructions. Nobody suggested a letter needed to be written, or that there was some defect in the way the instructions were received, given, or indeed acted upon. So viewed objectively, did the parties waive the need for a letter, if indeed a letter was needed? My respectful submission, yes, and that could as easily be the rationale for the determination of this case. The more interesting, more complex certainly, legal principles are those relating to estoppel by convention. I've given you the case of George on High because it illustrates the two principles I said. Firstly, the approach to contractual interpretation, but also a practical application of the rules in Tinkler. Let's start with the contractual points. 38, this is so familiar. I take it very, very briefly. Pink Floyd and EMI, talking about the question of interpretation of a provision in a commercial contract. It doesn't simply depend on the words used in that provision. It is also dependent on the other provisions of the contract, on commercial common sense, and on the surrounding circumstances or the matrix of fact at the time the contract was made. And it could be that what His Honour Judge Lethem referred to as a tight and focused approach is really echoed in what Lord Neuberger says here, which is you're not carrying out a detailed semantic and syntactical analysis of the words used. The process of construction, or the approach to construction, is much more nuanced than that. So, but what the COI argument really boils down to is, well, there's no letter. There's no letter, so there's no payment. But that's not the right way of approaching the interpretation of this contract. Because as 17 in this case records, the ultimate aim of interpreting such a provision is to determine what the parties to the contract meant by it. And that involves ascertaining what a reasonable person would have understood the parties to the contract to have meant. Well, the reasonable person would have seen that Mrs. Azhar had recorded in writing what she needed to achieve and what she wanted AMM to procure for her. So where there's reference to a letter in a subsequent contract, the parties will go, well, they've already agreed, they've already written down what it is they have to do. What the provision requires is something to be recorded in writing, and it was. Para 18 refers to the principles that the court will not hold a party to a word that may have been introduced in error. Something's gone wrong with the drafting. And I've already directed you, my lord, to the other uses of confirmation of instructions, which includes an application form, so that the definition is fluid in any event. So maybe letter is a misnomer. Maybe that is just the wrong word. Why would it need to be a letter? It's not always used in that sense. In relation to, in fact, sorry, finally, if you go, please, internal numbering, page 12, to paragraph 13. I've highlighted the following. Textualism and contextualism are not conflicting paradigms.
I think you can take it that we're familiar with
I'm
these
very grateful.
authorities.
I'm very grateful. Okay, so the more interesting principles derive from Tinkler and the circumstances in which a party will be estopped, having led the other side to believe that a strict legal right will not be insisted upon. Now, the point my learned friend took in his supplemental skeleton was that it would be wrong for me to make this argument because I'd be using estoppel as a sword. But the judge in this case dealt with that, and my respectful submission, the same principles apply. If I may please direct you to 103, internal page number 24. In which the learned judge cites dicta of Lord Boroughs in Tinkler. There are two further matters that need considering before applying the principles to this case. The first is whether estoppel by convention can act as a sword or is merely a shield. The second is whether, and we'll talk about the second principle in a moment. What Lord Boroughs says in Tinkler is, I've considered whether the submission about the scope of estoppel by convention relates to the question whether estoppel by convention can create a cause of action, acting as a sword, or in contrast can operate only as a defence, acting as a shield. In amalgamated investments, Justice Brandon examined this question in the context of estoppel by convention and said at pages 131 to 132, while a party cannot in terms found a cause of action on an estoppel, he may, as a result of being able to rely upon an estoppel, succeed in a cause of action on which, without being able to rely on that estoppel, he would necessarily have failed. That is, in my view, in substance, the situation of the bank in the present case. So I can't use estoppel by convention to create a contract where no contract exists. But the contract does exist in this case. It is her insistence on a particular formality.
Now, you say, here's a contract, you signed it, you're liable to pay me something. She says, no, I'm not, because there's no confirmation of
Exactly.
instructions letter. You say you're stopped from arguing that point.
I mean, it's pretty simple. It does boil down to that, in essence. I could tease out the further principles, but it boils down to that, is that clearly, in relation to the second finance offer, it was procured in accordance with instructions. She doesn't say it wasn't. On the contrary, she engages with it. So for her now to say, aha, but I never put it in a letter, well, that's inequitable. The reliance, my learned friend said, well, where's the detriment? Well, they did the same service twice. They'd already procured a finance offer for her. They had to do it again. So they had to go through the process of obtaining terms of finance a second time. And she had led them to believe, or viewed objectively, it can only be inferred that the parties believed that no letter was required. Otherwise, why would they continue to deal with one another for 3 months? It doesn't make sense. Nobody insisted upon it. Indeed, it wasn't raised until it was raised on appeal. My lords, those are my submissions, unless I can assist you further.
Yes. Thank you very much. Yes, Mr. Thrower, do you wish to reply?
Very shortly. I think we have a problem with the allegation that she gave instructions in relation to the final offer. That document at page 266 is an email from Mr. Smethurst.
Yes.
Relating to what had been achieved at the meeting the day before. And it says that the resolution is 850,000 by 21st of April and 5,000 per month for 12 months. He says, on the basis the monthly commitment will be unsecured and probably met from the rental income, we will focus on the 850,000 net proceeds required to finalise matters for the transfer of equity. So far, Mr. Smethurst, we know he's got a figure, and he is saying we shall focus on providing money for that figure. Rental income can take care of the monthly payments. And he says at the bottom, we can work out the gross loan required to complete with 12 months interest retained, so no monthly payments will be due. The maximum loan available on an estimated value of 1.9 million, which is the offer the other side claimed to have on the table, may well be higher than needed. If that's the case, you can decide if the additional funds are useful for you towards the planning cost perhaps, or whether to take a lower facility. Korea will obtain the maximum facility today based on the value of 1.9 million. If they gave you any evidence of that offer, please supply to Stacey. There's no evidence whatsoever that she gave instructions leading to the figures on.
Well, this email that you're showing us is sent on the 29th of March at 7:49.
Yes.
And the email at 264 is sent a few hours later at 12:41. And that starts as promised.
That's referring to what he said in the last paragraph. The problem with this is that he has said to her in her message that they would focus on 850,000 and 12 months interest. So we've got a period of 12 months and 850,000. That's what he says to focus on. Then at the end, he starts saying, we can work out the gross loan required, etc. The maximum loan is 1.9. It may well be higher than needed. If that's the case, you can decide if the additional funds are useful for you. There's no indication that she's given him instructions to work on that basis, the basis of 1.9 million. What he's saying from the conversation he's had with her is we can focus on the 850 for 12 months. What comes down the line is 1.235 million, less the 2 facility fees, legal fees, etc., for 3 to 9 months. There is nowhere any indication of her giving instructions for the document that appears on page 264. In fact, it's the opposite. When he says, it may well be higher than needed. If that's the case, you can decide if the additional fees are... Why would he be saying that if she'd instructed him? But it goes further than that, because interestingly enough, when she was cross-examined, this appears at page 167.
So I do have a concern, Mr. Thrower, that we're getting into arguing the case on the facts, which is not something for which you've ever had permission to appeal. Or was this a reply to Mr. Stevens' point about waiver and or estoppel?
Well, it's partly that, but also the fact that a reason being given for not accepting the confirmation of instructions letter is that you can read into other documents confirmation of instructions.
Well, there are 2 points there, aren't there?
Yeah.
One is a confirmation of instructions letter essential, or can you read confirmation of instructions as including other documents?
Yes.
Second question is, if you can read confirmation of instructions in the latter sense, can you find it on the facts?
Yes.
The point I think you wanted to argue in front of the circuit judge was the first question. Must there be a letter?
Yes, that in fact was all we had on the
Yeah.
leave to appeal. And on that,
If the answer to that is no, it doesn't have to be a letter, you can find it elsewhere in the documents, then whether you can in fact find it is not within the scope of the appeal, is it?
well, in terms of the appeal or in terms of the response, it's relevant in the response. But in respect of the appeal, what's been raised is there are other documents you can read it from.
Yeah.
And we say, well, if we can demonstrate that's not right in terms of what you'd expect out of it, it at least puts that to bed. I mean, we're talking here about an agreement entered into months after the fact-finding document. Now, why would you put a confirmation of instructions letter is required in a contract if 5 months before that, in a fact-finding letter, you had got the instructions? It doesn't make any sense. It would say, we have been given these instructions, blah, blah, blah. Their entitlement depends entirely on there being a confirmation of instructions. What happened 5 months before, if it was meant to be part of the arrangement, would have to be in the contract. No, they specifically said confirmation of instructions letter. Now, whether or not the point on appeal is good. It is submitted a question of law. What's been introduced, though, is, oh, but you can read it in other documents. That's trying to bring facts into what's essentially a legal argument. But even there,
Well, no, what he's saying is if you are right, then the parties have proceeded on the basis that you don't need a letter. That's the respondent's argument. Now, there may be a complete answer to that, or it may actually depend on the facts, in which case that puts us in a difficulty.
yes.
We're not a fact-finding court.
But essentially, the problem that went to the judge on appeal was a matter of law. Looking at this contract, the contract itself, which was produced by Mr. Smethurst's company.
Yes, but the point the circuit judge is making is, if this is a point of law, and if it's right, then there may have to be further evidence, which is called, in order to deal with it, of the kind that Mr. Stevens has shown us. It may not be complete, but of that kind, to support one or other of his two arguments based on waiver or estoppel. Now, you say there's no evidence that your client asked Mr. Smethurst to procure this alternative offer, and you are right on the documents as we have them. But that doesn't necessarily mean there could not be evidence which showed that.
That was a matter that wasn't raised at the appeal below.
No, indeed. Well, that's exactly the circuit judge's point. Because it wasn't raised below, there might have been further evidence called.
But the respondent's notice is bringing in new issues that weren't litigated on the first appeal, even though it's perfectly obvious what the appeal was about. And that's what the leave to appeal had been given for. It's points that are raised now, after the event, so to speak, because of indications that they might not be right about the letter of confirmation. And the concern here is that what's being relied on is that there is no hidden evidence. We've had disclosure. What my friend has referred to today is something that happened 5 months before in a fact-finding. And there are two elements of this agreement which refer to confirmation of instructions, but they're clearly not to do with the confirmation of instructions letter. They're to do with an application form and regulation that means an application form must go in. There are two references.
Sorry,
There was a reference made earlier on to the documents. Was it 244? I'm sorry, I think that.
You're referring to the documents from page 243.
Yes, that's 243 and 240 are the two. The first one is confirmation of instructions application form. That's something for regulation, as the judge said at first instance. The broker has been instructed by the client to obtain an offer of funding from a lending source. The following terms are those advised by the broker as likely to apply to any offer of funding. They are subject to the client's acceptance of the broker's formal terms of business agreement, blah, blah, blah. There's no confirmation for instructions there. The rest of it isn't instructions at all. There's nothing there except suitable insurance, appropriate life or insurance term, director's guarantees. This has got nothing to do with the confirmation instructions from the client. If it was to do with it, it certainly hasn't got anything in there remotely to do with it. Incidentally, on the next page, there's a further Schedule 3. And then we have page 243, Terms and Conditions Schedule 1 at the top. Before signing the agreement, the broker will complete a confirmation of instructions application form. The instructions, which shall be read and take effect if they form part of the agreement. Any change to or variation of instructions will not affect the liability of the client to pay any fee pursuant to the agreement. Again, it doesn't go anywhere because there's nothing in that application form. It's not aimed at what instructions the client has given. Now, the only other document that's mentioned is a fact finding, which is months before that. It's not part of the negotiations around the agreement or the term that was put in that agreement, which was meant to regulate the relationship between the parties. Which means that without that, what instructions did she give? How do you reach a situation at the end where she's liable to pay on something where there is no evidence she's given those instructions? And I think, just very, very briefly, if I could refer to page 167. Just to illustrate how shifting the sands can be in this case, and one door is closed, another door seems to open. At page 167,
Yep.
there's a cross-examination of Mrs. Azhar. And they're talking about a £1.9 million figure that came up in the mediation as something the other side had come out with. And then Mrs. Azhar is asked, Judge Arnold, they told you had a valuation of 1.9 million. I think yes. And then the question from my friend, and you asked Preyer, who introduced you to the claimant, to get an increased offer on your 1.9 million value, didn't you? That's incorrect, Your Honour. I've never spoken to Preyer. I've never seen Preyer. This question obviously means that Mr. Smethurst is not saying that she asked him to get something based on 1.9 million. My friend is asking, or is putting it to her on instructions, that you asked Preyer, the intermediary, to get an increased offer on your 1.9 million. There's no evidence that she went to Mr. Smethurst and said, I want an increased offer on the 1.9 million. That doesn't appear from the way she was cross-examined, and it certainly doesn't appear from the document that was sent on the 30th of March saying we'll focus on 850,000, but we'll get an offer on the 1.9 million, which may be too much for you.
Well, the district judge deals with that, doesn't he, at 26, paragraph 26, page 91? Isn't that where he's dealing with this?
But there's no, it doesn't deal with the fact that this doesn't reflect her instructions. Mr. Smethurst can't say, if it's put to her that she told Preyer to get a valuation of 1.9 million. She never talked to Preyer, so she didn't. It's only put to her because there was no evidence that she'd made that, asked that. And that doesn't appear from the beginning of that message from Mr. Smethurst on the 30th. He's talking about the 850, concentrating on that. But then this document they rely on comes in for a much bigger figure, presumably more money for Mr. Smethurst. And he says, this may not be acceptable to you. If she had instructed him, get me a, then he would have just said, there it is. But it's clear from the cross-examination, he's not saying she told him that. It's put to her that she instructed Preyer. It just simply isn't backed up by the documents themselves, nor, of course, is the fact that it was for 9 months, not for 12 months. Even though he had said 12 months at the beginning of the letter, and that was the period for the payments, or the interim payments. And the problem with cases like this, if you want a long-term loan, and you've got a situation where you've got a bridging facility, and you've got 12 months to pay this, that's fine. On the face of it, that sorts it out. Where is the instruction that 9 months will do? He said 12 months, but then it comes as 9 months. There's no instructions on the 1.9, there's no instructions on the 9 months. It says 12 months on the face of it. It comes back to the point that if one is balancing the equities of it, if she had asked for this, if there was any evidence, but the evidence points the other way. I think I ought to say also, just finally, that the authority on the shield and the sword probably does apply in this case. I think there's a lot of similarities with the two concepts, so I am not going to push that.
Yes, and although you mentioned in opening the appeal that estoppel by convention didn't apply to contract, of course, Amalgamated Investments in Texas was indeed a contract where the parties had acted on the basis that it meant one thing when in fact it meant something else.
Yes, I think the problem in that case is was it didn't turn out to be a contractual point per se at the end, because in effect they were importing a term that wasn't a contractual term, but it was a term that was assumed by the parties to be relevant. And the observations in that case were, we're not deciding it, but we don't see any reason why it shouldn't apply to the contract. Yeah. But it does show that there must be some difference to be taken into account on a contractual basis, to look behind what's a clear contractual obligation. Unless I can help it.
Right, well, thank you very much. Oh, I didn't realise the time. We will reserve our judgment. You will get a draft in the usual way, which will be your opportunity to correct our English, but not our reasoning. The draft comes with an embargo, which means what it says, so it can only go to the approved distribution list. We would hope that in the light of the draft, you will be able to agree an order disposing of the appeal. But if you can't agree a form of order, please make short written submissions, and we will make the form of order that we think is appropriate. Thank you both very much for your arguments.
All right.